Marques, thanks for coming on today.
Hey, Jason, thanks for having me. Good to be here.
Yeah, so in the criminal world, we're obviously all following the Purdue Pharma case in terms of the settlement that's going on, criminal litigation that may or may not come out from that situation. In terms of the bankruptcy world, how does that work? If there is a fine, is that something that can be discharged by Purdue Pharma? Because it sounds like they're also trying to file bankruptcy.
Yeah, so well, Purdue Pharma definitely has filed bankruptcy and has filed a very controversial bankruptcy plan. Generally, criminal restitution is not dischargeable in bankruptcy and can be enforced notwithstanding a bankruptcy filing. So payment of that is, I think, something that was already underway before they filed bankruptcy. And so once the company filed a bankruptcy, it would have been allowed to or been required to stop making any payments on the criminal restitution judgment. But once its plan was approved by the bankruptcy court, that was a component. Payment of that judgment was a component of the plan that the court approved.
So yeah, let's kind of back that up a little bit, because so you're trying to say that as prior to the bankruptcy itself, that was a debt that was like required for Purdue Pharmacy to pay as part of the bankruptcy?
Yeah, so before Purdue Pharma filed bankruptcy, it had already been criminally prosecuted and reached had a criminal judgment against it. Unfortunately, or notably, I should say, none of Purdue Pharma's principals, the Sackler family that owns the company, were actually personally criminally prosecuted. So this was only a criminal judgment against the company itself.
So can you explain that a little bit in terms of what type of bankruptcy did it actually go through? What did it file under?
So Purdue filed under Chapter 11, which is a restructuring chapter of the bankruptcy code. Very often it's used to sort of just sell a company to another holding company, and Sears and Toys R Us are good examples of that. Where a company's assets will be sold off for parts to another entity, and sometimes it lives on. In the Purdue Pharma case, however, the company essentially will no longer produce drugs, it will no longer market, and any sales that it receives on existing drugs are going to be put into a fund for the benefit of the victims of the opioid crisis that it helped to kick off with this, the patenting and marketing of Oxycontin.
So two follow-up questions to that. I mean, this is just kind of opening a can of worms in terms of all the legal things that go on. How does the sale happen? Is it someone that the Purdue Pharma found themselves, or is it like an open bidding process?
So in this case, there's not an actual sale of the business. It's because they own patents on drugs. Those are continuing. The drugs are continuing to be sold, and the profits are just being funneled into a trust. So the company really is right. Essentially liquidated.
Oh, I see.
It's basically been wound down. So the controversial part of the Purdue bankruptcy plan is that it involves what's called a third-party release, which are widely disfavored among bankruptcy courts. There's one court in White Plains, New York, that is known for approving these type of plans that include these releases, a third-party release of another person or entity that didn't file bankruptcy but can get a release similar to the entity in bankruptcy. So Purdue actually reorganized itself and headquartered itself in White Plains prior to filing, so it could take advantage of this one court that would enable it to file a plan that included a third-party release. The plan was opposed by almost every state's attorney general that was bringing claims against them for fraud and all the damage that they've caused with the opioids. And then, of course, there were hundreds of thousands of families of people who have died and people who have suffered addiction who also had claims. And so the third-party release allowed the members of the Sackler family individually to contribute about $9 billion into this fund to go to pay for treatment and recovery and possibly monetary damages to some people. And in exchange for that, they've gotten a release from any and all types of civil liability from any of these these individuals. Of course, $9 billion will be nowhere near enough to cover all the damage that's been caused to millions of lives. And the kind of the kicker of the settlement agreement is that they don't have to begin paying most of it for about a decade. So despite being, incredibly wealthy, and the family has, made billions and billions of dollars off of these drugs and sheltered their money pretty effectively, they'll be able to hold all their funds, and that money will obviously continue to grow until they begin making payments several years later. So, the settlement to them is kind of a slap on the wrist. It's probably very inconsequential monetarily to them, but they got off pretty much scot-free, other than the monetary part.
Well, Marques, thanks for explaining all that. So tell me, what about your day job? What do you do on a daily basis? What should people be calling Marques Lipton?
Sure. So on my daily basis, I'm mostly representing individuals and small business owners that are struggling with debt. I help them through the bankruptcy process or to do out-of-court workouts with the creditors. I help people get rid of credit card debt and save their homes from foreclosure.
That's wonderful. Well, I'll include your information in the post and chat here so people can reach out to you directly. But I appreciate you coming on today.
Nice talking to you, Jason. Thanks for having me.